aspects of student freedoms and responsibilities as a student and the student citizenship code. And one area that we will look at in particular is Article F, and that again deals with search and seizure. So would anybody like to speak on this at the moment? Okay. Oh, Mr. Arnodis, go ahead, Andrew.
Thank you, Mrs. Dunn. Thank you all for being here today. My perspective on this is I would primarily like to hear from the police department and our school administrators what they see as an ideal policy that fits within our boundaries and would make it, I guess, best suited for you to, keep the balance of, individual rights and privacy while also keeping students safe and doing your jobs. Frankly, I didn't have any major issues with the policy we had now. I know there's been some uproar that has been out there, and I think we're working on it to improve as we do everything we do in every aspect. So I look forward to hearing what the experts have to say, and I look forward to this discussion. But I would like to go with, when this ultimately comes to a head, with what the administration and the police department think is a mutual respect and beneficial policy for us to have. So that's where I land on this right now. Thank you.
Very good. Very well put. Thank you, Andrew. Okay. Steve Farrell.
Hi. So thank you very much. I just want to, reading through the policy, and this is the GIH section. It does state in paragraph 3 in here, searches by school officials of students' automobiles or the student will be conducted. I just wonder if there could be some clarification at the very beginning, maybe the first paragraph, because it leads off by stating the right of the inspection of students' lockers. It'd be nice to have, kind of a general open description that the school has the right to inspect, anything, students, anything to do with anybody on our property. And, I'll leave that up to the law offices to clarify that a little more. But just as a general reader, it starts off to me a little wonky. It goes into the locker issue and not general searches.
That's a good point, Steve. Thanks. Captain Zawacki, would you like to give us some information in that regard?
Certainly. Let me first start by saying that obviously the goal of the Peabody Police Department in interacting with students is to obviously keep them out of the criminal justice system. We want to handle most of the things we can in-house between administrators and school officials. In reviewing this just briefly over the last couple hours, when I received this invite and trying to get up to speed with where we are, in looking at your policies, so I have a couple things that just to kind of throw out there. The first thing is, obviously, as police officers, we are bound by certain laws, search and seizure, Fourth Amendment, that extend to us against unreasonable search and seizure. Those laws are different for school administrators, although you are government officials because you're public schools. So there are different parameters that come into play. However, your policy that you have that I begin to read obviously is in compliance with the model policies from your organizations. I can first tell you that looking at JIH, the first issue I have is interrogation. Interrogation is not really, in my opinion, the word that we use when we're interviewing or talking with students pertaining to witnesses, victims. Interrogation is something that happens that police use for those people who are in an accusatory where there's certain things that happen with interrogation. It happens with Miranda, things of that nature, custody, interrogation. That's where that word comes from when it comes to the policing end of things. So I think as you look at the policy, we want to talk about, are we interviewing students, a school committee, a school staff, are they interviewing people, are they talking to people? Immediately by throwing out the word interrogation, you're you're saying that somebody has done something wrong. The person that you're talking to is obviously guilty or presumed that there is an issue with, because we're interrogating them. I think that's the beginning of this. In moving into the next step, there are a lot of parts to this. Lockers, persons, throughout the different aspects. There's certain things that pertain to lockers. There's certain things that pertain to reasonable suspicion, blanket areas that are all parts of this that we should discuss. So those are just some initial thoughts that I have, just from the title. Moving forward, I'd like to hear anybody else's thoughts.
Okay, thank you. Actually, it is a good point. The word interrogation is very specific for law enforcement, and that is something that if we can find a better word that might fit better with our actual intention with the use of that policy. Okay, and I do know the lockers and persons. The language is inconsistent because in another spot it talks about backpacks and pocketbooks. So if we could make it more of a consistent language throughout that policy and the other ones that are related, as well as especially in the student handbook, that probably would help. Joe, did you have a question?
I just wanted to add through the chair, and Captain Zawadzki, you had a great point. I don't like that word interrogation either. Maybe something along the lines of something having to do with information. That might be the way to go. But I would definitely, I'd love to hear again from the professionals, from our administration, and obviously from our legal end as well.
Okay. All right. Dr. Lord.
When I was working as a assistant principal and doing discipline, the terms that seemed to be most pervasive in these conversations were, on the police side, was just cause, and on the administrator side, it was reasonable suspicion. And that reasonable suspicion, there was a line that was analogous to a parent. If a parent had a suspicion that a child had a controlled substance in their backpack at home, then the parent would go up into the kid's bedroom and search the backpack. So that kind of analogy seems to be common out there for these kinds of searches. And I think that maybe the word is just, we can question a student rather than interrogate a student. Question might be a better word. But that's just my suggestion.
No, it's a good one. Thank you. Okay. Dr. Kerbel. Or Mark, you're muted.
I'll defer to Mr. Hockman. He had his hand up before me.
Oh, that's okay, Doc. You're okay.
Okay. So when I look at the policy and I try to think this way, what makes sense? Some common sense. So when I look at this, it says an effort will be made to contact the student's parent or guardian, so the responsible individual may be notified of the situation. And so why was that in there? Okay. And if it's in there, do we need to add to it? So one of the common sense question is, I said to my wife, if this happened and this was your daughter, what do you think? Would you like to be there? Would you like to be notified? Is being notified enough? So what's common sense? And so when I think about whatever's applied to my own child, or good enough for my own child, is good enough for others. So I am struggling with this line. An effort will be made to contact the student's parent or guardian so the responsible individual may be notified of the situation. So does that mean the school has, in local parentis, total control, or as a parent, do we have some say in the matter of search and seizures or search and questioning or whatever? I'm just grappling with that.
No, it's a good line of thought, actually. Mr. Hockman, Jared.
Thank you. Good to see everybody tonight. Captain, nice to see you too. So I think Dr. Lord, identified the standard. I think the standard is reasonable suspicion. And I don't see that language really within the policy. I think that's the only standard that we need to satisfy in order to search. I think it's the only standard that the police need to search. So we don't have any language in the policy as I see it regarding detention of persons. And it's assumed that if we're going to interview someone or whatever word we're going to use, I agree, I don't like interrogations either because it connotes custody, custodial arrangement or relationship. But if we're going to detain someone to interview them, there are also Fifth Amendment rights in the US Constitution that we're talking about here. And to Dr. Kerbel's, which I think we need to address in the policy, to Dr. Kerbel's point regarding, notifying parents or attempting to notify parents, I think we also need something that addresses exigent circumstances. I mean, there are times when parents can be notified and a student can sit and wait in order to be questioned by whether it be Mr. Busey and his staff or the principal of a building and his or her staff, or not, depending upon what the circumstances are. And I think we, to the extent that we can, and I don't know, I don't really have, too much knowledge in this, but if we're able to, as school officials, as school department officials, before it would get handed over to the police department, if it ever were to rise to that level, are there circumstances where we can question students and or search their personal property, whether it be a car, a backpack, a purse, a locker, pockets of a jacket or clothing, without parents being notified or present?
Okay, thank you. Thank you. Good points. And I just want to say two things. One, Josiah, would you be able to help Mr. Olympio get access to the Zoom meeting? He's having trouble connecting with us, and I think he's trying by telephone right now.
I do see him as an attendee. I can bring him in as the host if that's what he's interested in.
Yeah, he's actually, if you can bring him in just so that he's able to participate in the meeting. I'm not sure, he may be on there now. If you can see it, maybe he is on there.
I can see him. Okay, she's a panelist now.
Oh, good. Okay.
We're good.
All right, we're good. Okay. Now, the other point that I do want to bring up right now is we're discussing, specifically only one piece of our policy, and that's JIH, over the past couple of minutes. However, as with any policy, there are multiple policies on file, and you have to read it in line with JIJK, which is about search and seizure. You also have to look at the language that we have in the student handbook. And the language in the student handbook actually says, search of a student's person, car, or possessions will occur when there is reason to believe that the student is hiding evidence of an illegal act or a school violation. When practical, the student may be present when a search of his or her possessions, including automobiles, is conducted. Items confiscated during an inspection, investigation, or search will be held by school administration pending further investigation or disciplinary action. It also talks about, just cause and reasonable suspicion. A student searched by public school official or teacher will be found reasonable under U.S. Supreme Court standards if there are reasonable grounds for suspecting, if the search itself is conducted in a manner reasonably related to its objectives and not excessively intrusive, and reasonable grounds for student search may include, for example, a school official's personal observation, the official's receipt of a report, and then it goes on in the handbook to say searches of student lockers, backpacks, pocketbooks, and cars on premises, and it lists different reasons why a search might happen to be conducted. And it also says the school retains the right to inspect backpacks, pocketbooks, and students' cars on the premises for compliance with these rules. So a lot of what you're all bringing forward are actually covered in different places within our policy and within the student handbook. And I do think that we can see some issues with some of the language here, but I also know that the rules dealing with juveniles have changed. They've definitely changed. Now, the policies that are on file with MASC are actually current as of 2019. I believe it was it 2018, Captain Zawacki, you would, I'm sure, be the person that could answer this. Was it 2018 when the changes came through, or was it last year when the change with juvenile involvement with law enforcement came through?
There was partial juvenile reform in 18 and then into 19. It's kind of continued to evolve to where we are today. But a lot of changes, we have seen a lot of changes in the last 2 years regarding juvenile law. What can be, ages, what can be charged, over the last couple of years, there's been quite a bit of change.
Yeah, that's what I thought. So dealing with that, this probably is a good time to review our documents and update them and make them, because overall, every one of the policies says we have to conform with state law. And if state laws have changed, then we also need to reflect that in our policies. So I think that's what we're going to need to do, going forward with this. And
Ms. Dunn, I don't know if you can see this or not, but Mr. Amico had his hand up, and then Mr. Betancourt had one as well. I don't know if that's something you can see, but Mr. Amico and then Mr. Betancourt.
Okay. Mr. Betancourt, Mr. Mayor, did you want to speak on this? Oh, you're still muted, Teddy. Okay. I'll get to you in a minute, Mr. Miko, just a second. But what I was saying is we do have a lot of different pieces that all need to fit together. And one of the other things I think that we school committee members need to realize is we're talking about, in one respect, two different levels of involvement. The goal of the police and PBD and the goal of our school resource officers is to prevent a child from getting involved in the justice system. So not every incident in school is going to rise to the level of actually even needing police involvement. The duties of a school resource officer are to assist, but those are very specific as well. So I think we need to look at some more information going forward as well, just to find out what would work for our administrators and the teachers and the staff, and a procedure that would work for them before it got to the level where law enforcement was involved on an official level. And if you can understand what I'm saying, our school resource officers are involved with our students on a different level than calling a police officer in to interrogate. Captain Zawacki, can you straighten me out on this one? There's a different level.
Certainly. I think the relationship, the expertise of our school resource officers and our juvenile officers, the expertise that they possess, it is very important. Think about the partnership that we've asked to create between law enforcement and teachers and students, because, like you said, even matters that maybe outside of school could evolve into a criminal situation, oftentimes are diffused and held and dealt with on a level that never gets to that, rises to that level. And I think that is the major importance of having that relationship with our school resource officers and administrators, teachers, the students, everybody that's involved with the school system, so that we can, they're the communicators, they're being able to move in different directions, and not into this system, our system. That's the whole point, is to prevent that. If I may step back 1 second and say that we often in government have issues where we have 2 or 3 things and we feel we deal with the same thing. 2 or 3 different policies, or a handbook, like you mentioned. Now you have a handbook, you have this different documents. And sometimes even small items are contradict each other. And it's just how important it is to have everything read properly so that you don't look in 3 different locations and get 3 different answers. It's
Right.
very important. I just wanted to throw that out while we're discussing.
No, it's a good point. Thank you. Yes, I'm going to back up 1 second. I see you, Dr. Kerbal, but I'm going to go back to Mayor Betancourt. Teddy, did you want to have some input right now? Okay, I'm going to go to Joe Amico. Joe, you wanted to say something?
Great.
And I'll get to you,
Thank-
Dr. Kerbal.
Thank you, Brandy. Excuse me. Thank you, Ms. Dunn. I was just thinking if all the other districts have to go by the state law, we have so many resources out there that basically govern our schools anyhow, whether it's the DESE, and for us, for the school committee, the MASC, for superintendents, the MASS, and overall our legal group. So I'm thinking that we should probably reach out to MAS, the MASC, the MASS, the DESE, and our internal legal group, along with our police department and along with our administrators, and just come up with something that, we're no different than most districts, demographically and population and size wise. So why not look at what other districts are doing? A Haverhill, an Andover, a Revere, and anyone who has a group of students or the number of students that we have, and we have those resources. So I don't know if it's something that we actually have to create, or something that we can actually just look at what everyone else is doing and create something from that. I think that might be the best way to go.
Okay. Mrs. Baker, I can
Coming up is Ted Betancourt.
yeah, that's why I kept calling on the mayor. I didn't know until I saw your picture there. I will allow you to speak, but this is definitely a subcommittee meeting where I do allow members of the public to speak, but I do want everyone to know we are on a strict timeline, and we are sticking with the issue of the policy. So
Yep.
if you can speak to that, go right ahead.
Absolutely. I think it's being a little bit overthought. There's already a mutual understanding of agreement between the Essex District Attorney, the Police Department, and the Peabody Schools. And it's really outlined right in there what is permissible, what is not, when a police officer is supposed to be involved and when he's not. Unless it's criminal activity or de-escalation is needed immediately. His more of a role, according to the documents that were signed this year, is to facilitate a relationship between the students and the police department, and not so much be threatened with them, but to form a relationship. Should there be imminent danger? This is all, if you look at, we've gone over before the law, and as you said, reasonable suspicion, which also has to be narrowed down. I talked to Chief Griffin about interrogation. That's intimidating to a child, and it's not the appropriate term. They're not.
Oh, I'll be honest. I don't mean to interrupt you, but I will tell you, I don't think you had come on immediately.
I didn't.
Oh, okay. We did speak about the word interrogation, and
Okay.
we want to change that
Good.
terminology, and we did discuss that, and we also discussed the fact that we do have a lot of different areas that we need to look at in order to pull everything together so that it is cohesive from one document to another.
Okay, yeah, if you check that paragraph out though about search and seizure and the MUA, it's pretty clear exactly what it is, what the role of the school resource officer is. And it also talks about, you can go into, and I believe I got it off of the, is it DESC? Their website that outlines as well what you would need to meet in order to do a search. And it's basically something illegal like drugs, imminent danger, guns, things like that. But you can't suspect a group of 30 people over the word, of one. It has to come from a credible source.
Mm-hmm. Right. And
this field has to be narrowed down.
Yes, and we've got that in here in the excerpt from the student handbook. Just a piece of history for everyone. I remember when we did work on this policy, back, I want to say it was probably 2008, 2009. And at that time, there were numerous meetings between the police department, the district attorney's office, and the school committee and school administration to create not just that MOU, but also to make sure that the policies were workable, that this would work. And this was done because it was really geared more towards the high school age students. So a lot of the discussion involved the high school staff for the implementation of this and working out, the responsibilities of each party and how it would be handled. So I think we also are going to need to look at that factor, because even in one of these documents, it speaks about making sure that this, like for a search, that it's conducted in a manner reasonably related to the objectives and in light of the age of the student and the nature of the infraction. So that language is in there so that it can be adjusted to whatever the situation is.
Ms. Dunn, I don't know if you see, there's two hands up. Mr. Arnottis was first and then Mr. Amico.
Okay, Mr. Arnottis, go right ahead.
Thank you. Through you to everyone, I actually just want to piggyback on what Mr. Amico had to say. I think he hit the nail on the head there. I think possibly the best strategy for us might to be take what the MASC puts as a standard policy on this. Maybe we take in some of the additional policies that other districts have. Perhaps if they're willing, if we could have the police department work with the district and perhaps our legal counsel, put something together that looks well-natured to them, then it comes back to us, and then we could move forward with it. If we need to make any changes, obviously it would be presented to the public. But I think that might be the most efficient route, as Mr. Miko mentioned, rather than trying to start from a blank slate right now. I think, we have the time. I can't imagine us doing anything, considering we're not back anyway, but, before the fall. So we have some time here to get this done and get it done well and allow folks to work on it and check things out where they see fit. So I think that might be the best strategy for us to take right now. Look at things, have the experts weigh in on it, and then perhaps, we can get something back, run through it here as a subcommittee, and then bring it forward to the full board and move forward.
Thank you, Andrew. Actually, that is the plan. And that's why we've got our expert, Captain Zawacki, you're the expert now. And also the district attorney representative for juvenile justice is also going to assist with reviewing whatever we do come up with. Presently, I will tell you, what we have now actually is what MASC has on file as the model policy. And of course, we are able to adjust these policies however they work for us. So we're not really going to be starting off, starting from scratch. We're actually starting from a good point. And I can always get samples from other cities and towns and see if they have anything, in addition to what we have. But I will tell you this, what we have actually was created through a partnership with the schools, with the police, and with the district attorney. And that was why I invited them to come to this meeting, because it worked well the last time. And now, moving forward, it should work well again. And as Captain Zawacki pointed out, we've got new regulations dealing with juveniles, and we do need to look at that and make sure that we are conforming with those regulations as well. We've got Mr. Busey and Dr. Lord here as principals, and I think that that's a really good piece of the puzzle, because the principals of each of the buildings, and we probably should bring in some elementary school principals as well, even though, it's difficult to think of little kids being involved with searches and potential law enforcement involvement. But in order to cover every level of the school district, we probably should have some input from them as well. There could be times when they need some guidance on this. The language definitely applies to every level. and can be used for every level. But I do think, being mindful of situations depending on the age of the students, that we need to make sure that we put that in place as well, just as a guidance for our staff going forward, so that they know what's expected and what we would anticipate with the need for a search.
I just got a little reminder. The next meeting starts in 10 minutes, and Mr. Amico still has his hand up.
Oh, okay. All right, Mr. Miko, go right ahead.
I think I almost forgot what I wanted to say. Actually, I did. So it must have not been that important. I'll yield and I'll come back.
Okay. Thank you. Mr. Hockman?
Yeah, Bev, while we're talking about updating policies, I just want to point out in, what is it, JJ/JK, section C4, which talks about tobacco, alcohol, and drugs. I know we updated other tobacco policies to include vape and
Yes.
smokeless tobacco. We're going to need to do that there. And in paragraph C6, I don't know, I don't want to put Captain Zawacki on the spot, but boy, this sounds like, to me, like it may step beyond. It says students must obey all oral or written instruction made within the scope of authority of school personnel. I mean, if there is a situation, a custodial situation that develops, and a principal or a staff member questions a student, and we have a policy saying they have to answer, that seems like it may be a stretch as to what school personnel are able to do. You got an opinion there, Eric? If not, don't worry. I mean, I just brought it up and we could talk about it at a future meeting.
No, I have no problem discussing it. I'm just taking a quick look at this. So let's be very clear on the fact that the requirements, the threshold for us to meet as law enforcement for a search, for a seizure, is different than that's spelled out in the law for school administrators. Again, school officials do need reasonable suspicion. And what's outlined in your handbook and those rules, in accordance with the guidelines that have been set forth, as we discussed earlier, nobody's trying to reinvent the wheel. I think that was a great point to make. There's already things in place that we have in place in this city that are up to standard. Are there ways that we can do it better, tweak it, make some changes? Absolutely. I think that's why this meeting is happening. But there are definitely different agents of, who's acting on whose behalf when it comes to search and seizure. And I will say, and that is spelled out as was discussed about in the memorandum of understanding between the school department, the city of Peabody, the police department, and the district attorney's office. So what is the threshold and required by administrators and us are two totally different things, Mr. Hockman. So I agree but that's how you word that in your documentation, I think needs to be looked at by legal on your side.
Yeah, no.
And actually, I don't mean to interrupt you, Mr. Hockman, but I can tell you that language is found in numerous other places within the policy manual for all different areas of school administration. So we can look at it. We will definitely look at it, but it's also utilized in a lot of other spots for other different situations. It's kind of like the point. So, and we're actually, Ms. Maccarelli and I are reviewing all of our policies, and we are going through each individual policy, looking for out-of-date information, out-of-date language. And this would be one I will just make sure that we find that throughout all of the policies. We're going through the whole book. It's a bit of a lengthy process, but we're going through the whole book.
Sure, and I think in most situations it's appropriate language. And I mean, students need to listen to staff's directives when it comes to a custodial situation, and potentially a statement made by a student that is potentially used by the district attorney in a proceeding. I think there are certain rights there that need to be addressed. That's all I'm saying.
Okay.
It looks like Miss Dunn, Mr. Amico remembers what he's going to say, I think.
Yes, and then and Dr. Lord, keep us on time. You're the timekeeper right now.
Thank you, Dr. Lord and Ms. Dunn. And the other thing that I was going to mention was a lot of this could probably fall into some purview of our safety subcommittee as well, because as we do construct this policy, there will be some discussion about safety measures that, you know, we really shouldn't be speaking about in public. So I would think as we craft this, we could also get our safety subcommittee involved as well, where we can bring in our police and our legal group as well and discuss some of the parameters that will be included in this policy. Thank you.
Okay, thank you.
We
We've
have
got-
3 minutes, folks, and I'll just add one thing. The threshold that Captain Zwacki was mentioning, at least at the high school side, is controlled substances, physical violence, theft, and weapons. Those are the 4 things that would involve the officers at our level. The rest of the other stuff, and even some of those things we can handle in-house. But those are the 4 things that get the police officer involved: theft, drugs, weapons, and violence.
Right. And I mean, that's the thing, we're all working hard to make sure that the kids don't get to the point where law enforcement has to take enforcement action. It's to try to keep the kids, to keep them safe, to teach them, you know, right from wrong, and to be able to make sure that all the other students in the building are safe as well. Okay, if we probably only got 2 minutes left, but Mr. Ioannidis or Mr. Olympio, as the other 2 members of the subcommittee, do you want to have anything that you'd like to add as a wrap up? No? Okay, all right. Well, thank you all very much. I think this is absolutely just our very first meeting. I would like to schedule a second meeting on this. I will check with the schedules. If possible, I'd like to do another meeting right before regular school committee meeting in 2 weeks. I will send out some of the materials that we're referring to and additional ones. If anybody has any questions, you know, feel free to write in, and we will continue. And at our next meeting, Captain Zawacki, we'd love to have you stay with us on this. We need your expertise, and we will probably have a member of the district attorney's staff with us as well. So I thank everyone for coming, and I do appreciate your help on this, and we're going to make sure that we do this right. So thank you, and we'll go to our next meeting. Dr. Lord?
Yep, 1 minute, and what has to happen is everybody has to decompose from this one, and then the next one reevaluates. We can only have 1 Zoom meeting going at a time.
Okay, all right. So we'll all sign off and see you at the next 2 are executive session, and then at 7 we'll have our regular meeting.
Got it.
Okay, all right. Thank you, everyone.